Our first speaker is Professor Charles Reed Jr. of the University of St. Thomas School of Law, speaking on the Canon Law of Arbitration.
Ms. Freer, or is it Dr. Freer?
Dr. Freer.
Dr. Freer, thank you so much for that introduction. And I've written on the issue of arbitration in the Catholic Church, and it turns out to be a rather complicated story. But I will try to break it down in a digestible format using a series of hypothetical examples. And I'll begin by saying that there are three basic avenues for arbitration or conciliation to take place within the Catholic Church. One involves the arbitration or conciliation of what are called administrative acts, the decisions made by public authorities in the church, bishops, let's say, or pastors, people holding office within the church. Others are matters of private dispute resolution, making use of Catholic auspices to arbitrate disputes. And finally, what I find the most fun, most intellectually entertaining, if you will, is the issue of papal arbitration, particularly in the world of international disputes. But I'll begin with administrative arbitration. And let's take a typical example of an administrative act. A bishop is reorganizing the school system of his diocese because of financial exigency, frequent occurrence these days in the United States. The Code of Canon Law gives parents the right to educate their children in the faith, gives children the right to receive such an education. These are positive grants by the Code of Canon Law. It also gives the bishop the authority to see how to perform these, to carry out these functions within the diocese. You could have, and there are avenues of litigation where you could take these sorts of cases to Rome. It's difficult, it's obscure, it's expensive, it is vastly time consuming. You don't want to do that. But Canon 1733 of the Code of Canon Law allows for conciliation. It's non-binding conciliation, but it allows for conciliation. And bishops in such situations are encouraged to take that path, sit down perhaps with parent groups, sit down with affected constituencies, and try to come up with a conciliation, a settlement of the dispute. Again, non-binding, lacking legal authority under canon, legal bindingness under canon law, but a means of trying to resolve what would otherwise be a very tension-filled and often angry process. So that's one approach. Then we have also Canon 1713 to Canon 1715, which involve the arbitration of private disputes between private parties in the Catholic Church who may want to make use of specifically Catholic arbitration. There are two codes of canon law produced in the 20th century, 1917, 1983. The 1917 Code of Canon Law clearly contemplated a European situation where arbitration and dispute resolution often took place under what are known as concordats. Agreements, treaties really, between the Holy See and relevant European nation states, allocating judicial responsibilities often involving Catholics. And the Code of Canon Law was written with that in mind, the 1917 Code of Canon Law. 1983 Code of Canon Law is broader, more generic, lacks the kind of European focus that the 1917 Code of Canon Law did. But I nevertheless explore a couple examples of situations where we could see arbitration take place. Say, for example, a labor dispute or an employment dispute within an archdiocese, where we have perhaps a clause calling for religious arbitration, or perhaps the parties decide to seek religious arbitration of their dispute. Or another example I give in my paper, a Catholic couple, a seriously Catholic couple who divorce but want the property settlement that they reach to be handled not by the judiciary but through religious arbitration. A final example I give, because the Code of Canon Law does not limit this arbitration to Catholics. A playful example I give is I call the case of two Protestant pastors who have a problem, let's say, with the example I give is little involved, but a case of tree blight. Their properties are adjacent, and you have a case of tree blight, calling for the removal of trees that are owned in common by the two congregations, and how do we allocate costs there? And the example I give is rather intricate, but they are friends with the bishop, and they sit down with the bishop, and they arbitrate it through a court of canon law. Courtney,
Thank you
you
so
look
much.
like I'm about to run out of time.
Sorry, Professor Reed. This is fascinating. I'm sorry to cut in.
Then let me just finish real
Okay,
quickly
sorry.
and say the third example is papal arbitration of international disputes. And there I give the example of a famous 1940s case involving Canada and the United States called the Trail Smelter case, involving environmental degradation, externalities, and all sorts of things like that. And I suggest that maybe papal arbitration could help in the case of Catholic countries that encounter these sorts of things. Anyways, thank you, and I went over time. I'm sorry.
No, thank